Your Honor, this comes on our motion to strike. You currently have before you a 5-count indictment that was returned on September 16th, 2024. The makeup of the indictment was designed to cover a whole series of circumstances. The 5th count was use of a firearm in the commission of a felony. In addition, there were 2 additional indictments relating to child abuse and child neglect that were then sought through direct indictment again in December. I'm moving to strike all of those charges. What we have up to this point in terms of evidence, Judge, we haven't heard a single word from a single detective that was involved in the homicide division. We haven't heard any sort of credible evidence relating to what was espoused as a theory of catfishing for years now and had been working toward that. In fact, you have the only person that has even suggested anything, and this is probably the 3rd or 4th time that story has changed, is Juliana Magalhães. She's now testifying to what appears to be intended to fit right into whatever the Commonwealth's theory was regarding that, but doesn't even make it that far. She can't answer any questions with any sort of detail. In fact, without the absolute direct and oftentimes leading questions related to the Commonwealth, she wasn't able to answer a single thing. We went through in painstaking detail the numerous messages that at one point she might have said something about, but now she doesn't remember. In fact, I'm not sure her testimony is worthy of consideration, because she got to the point when I would ask questions, she would say, if you keep asking questions like that, I'm just going to tell you I don't know. And that happened numerous times, despite the fact that we patiently went through the evidence that we needed to go through in order to test and challenge her story. That story doesn't amount to, even in the light most favorable to the Commonwealth, something that's sufficient in order for these charges to go ahead. The charges themselves are an interesting, and I'll paraphrase essentially what needs to be shown, is that my client killed Joe Ryan after killing Christine Banfield. And the alternative, my client killed Christine Banfield after killing Joe Ryan. Then the next set of charges, which at least scream out that they're just a catch-all, is that my client killed Joe Ryan and within 3 years killed Christine Banfield. My client killed Christine Banfield and within 3 years killed Joe Ryan. We don't have any sense of what happened on that day, even in the light most favorable to the Commonwealth. There's no indication of who was killed and then who else was killed. There's no evidence to support that even in the light most favorable to the Commonwealth, under that statutory or that indictment scheme that was presented by the Commonwealth's office. As to catfishing, there's no indication, and there's certainly no evidence that would be credible toward that. And the Commonwealth committed during my motion for bill of particulars in September that was the theory that they were going on. Obviously, that doesn't appear the case because there's just not sufficient evidence. So we move on then to the evidence of Ms. Graff and the testimony. She tried desperately to paint a picture. Crime scene reconstruction, though it may be available all around the world, is not available in Virginia. And one of the reasons why this testimony has probably not met where the Commonwealth needs it to meet is that there's no indication as to timing. And those 4 indictments are all about timing. And so this isn't something that, hey, if they get close with their evidence, this is about in the light most favorable of the Commonwealth, they have to have a prima facie evidence as to each individual indictment. And the way it currently sits now with no timing evidence, with no actual confirmational evidence, first regarding that whether or not Christine Banfield, which is the threshold that they have to have shown at this point, is that she somehow abandoned her devices and this scheme came into place, which we've heard about for a year from various motions and various pleadings. And so this is the time when you're in a situation where you have not heard from a single homicide detective, though there were at least 12 in place at the time. You haven't heard a single thing from any of the command staff about this investigation. You haven't heard anything from the people that were doing this investigation except for Detective Leach. And Detective Leach has a specific purpose in this, and this is to introduce the items of evidence that he took photos of and the items of evidence that he sent away to the lab. There's nothing in any of the lab analysis that's been said that would implicate my client. And in fact, in listening to all of the evidence, it appears the testimony, the identification of any blood, if it was even done, would show that Joe Ryan and Christine Banfield are the contributors. This, Judge, is not surprising given the horrific situation that was there, but it was a situation not of my client's making and was not something that he did. And so, Your Honor, I don't believe there's sufficient evidence, even in the light most favorable of the Commonwealth, and I believe that there's an obligation when you have someone who has changed their story so many times on the part of the prosecuting authority to take that into consideration. But let alone those issues which will be taken up, I guess, at a later time, we have these indictments, and those indictments are the indictments that they chose to seek. They're the indictments that they had to work toward in order to be able to present the prima facie case, or in the light most favorable of the Commonwealth. Your Honor, I'd respectfully suggest that they've missed their target. There's not sufficient evidence, and I'd ask that you strike the five count indictment and even less evidence regarding what was indicted later on, which are the child-related charges. And thank you.
All right, thank you. Yes, ma'am?
If there is anything specifically the court would ask the Commonwealth to address. If not, I would simply point to the court that in the light most favorable to the Commonwealth, the evidence has been presented that Mr. Banfield shot and killed Joseph Ryan, that he stabbed his wife Christine, that all of that was done while his 4-year-old child was left in the basement, unattended, in a home where weapons were not only present but were in use, that the event in the light most favorable to the Commonwealth was in fact staged by the defendant in conjunction with the assistance of his nanny, and that at this point, I believe the evidence is sufficient to meet the standard before the court.
All right, thank you. Anything further your motion, Mr. Carroll?
No, Your Honor.
Okay. In the factors of this case, just for the record, there's two different numbered indictments. The indictment 2024-666 are the indictments with the 4 counts of aggravated murder and a use of a firearm. As far as the 4 counts of aggravated murder, 2 of the counts are under Virginia Code 18.231 subsection 7, and 2 of the counts are under 18.231 subsection 8. As to the evidence in this case, in the light most favorable to the Commonwealth, I do find that there is evidence that can be considered by the jury for each of the elements of aggravated murder as they are outlined in the indictments count 1, count 2, count 3, and count 4 of 2024-666. That's based on the co-defendant's testimony, crime scene testimony, blood evidence testimony, and DNA evidence testimony at this time for those 4 counts. And as shown in Virginia, the Commonwealth can indict a defendant under subsection 7 and subsection 8 for the same murders when each of them constitute murders occurred as part of the same act or transaction, or in a 3-year period. So they don't have to choose at this point during the guilt or not guilty phase as to those 4 indictments. As to count 5, the firearm, there is evidence to go forward that the defendant did use a firearm in the commission of these acts. As far as indictments under 2024-873, count 1, child endangerment and count 2, child abuse. In these matters in Virginia, it has been found that you can put children in situations that would constitute child endangerment and child abuse. In this case, we have evidence from the co-defendant's testimony that the child was brought into the house, brought into a crime scene. And the light most favorable to the Commonwealth would be that she was there during the occurrence of the events that had happened to her mother and to Joseph Ryan. And therefore, there is evidence for child endangerment and child abuse. And it is clear in the Virginia law that you can go under both the child endangerment and child abuse, and it's not double jeopardy because each statute requires proof of additional facts not found in the other. So that's 2 distinctive offenses. So based on that, and as far as the co-defendant's testimony, I cannot find, as a matter of law, that her testimony was incredible. The weight of the evidence is up to the fact finder, so I'll deny your motions at this time.